I can read brief profile of yours.
Okay.
So welcome again all the participants. Good afternoon to all of you. In the second session, we have with us Apoorv Sir as our faculty to deliberate on the topic IBC and its interplays with the other laws. So I would like to read his brief profile. He is an advocate, insolvency professional, and a qualified independent director. Currently a partner in VGC law firm. He is a former judge in District Court, Delhi. As an advocate, he represents insurance company, banks, and financial institutions and other public sector undertakings before Supreme Court of India, High Court of Delhi, NCLT, NCLTs, and various arbitral tribunals. He has taken assignments as an IRP and RP, written many articles and contributed to many law books on different subjects. Recent one big commentary on the Insolvency Bankruptcy Code as co-author published by Taxman. He has been a resource person for IBBI, ICSI, IPA, Delhi Judicial Academy, Indian Law Institute, State Bank Academy, and other universities in law. We welcome you, sir, on the second session of today's workshop to deliberate on the topic. Over to you, sir.
Thank you. Thanks, Anjali. It's a session where I think after having lunch, everyone should begin with a lighter mood because everyone is in a might go into a sleep mode. So just I start with a joke. When I saw that IPA's this refresher course brochure, with my time slot, it started at 1:30 a.m. So I thought how much time I will have to give to the participants. And later I realized that it coincides. And so it is only going to be a lunch time. And all of us had not supposed to wake up at 1:30 a.m. But having said that, the session is a bit intense. And I think I've been told all of us are IPs, but many of us may not be advocates. And are there some participants here who are also company secretaries only and not IPs?
Yeah, hi, Arun Ulge here. I'm not an IP. I'm just a
There are
CS.
some participants who are not IPs, but only CS. So, because an IP would still know certain legal provisions, certain legal background, but I'm not sure about company secretaries, whether they'll be. So I'll try to keep pace with the audience. In case you find me a bit fast or very slow, then please let me know. Then we'll accordingly, I can modify my way of speaking also. So first we'll begin with our subject is interplay of IBC, Insolvency and Bankruptcy Code, with certain special acts or certain acts, other acts of Parliament, in case there is some conflict. So how those other acts are applicable to CIRP or liquidation process. So we'll start first with EPFO, the Employees Provident Fund Organization. I'll just share the slide with you. I hope everyone can see the screen, see the slides.
Yes, visible, please.
Visible?
Yeah.
Right. All right. So this is on interplay of IBC with the Employee Provident Fund and Miscellaneous Provisions Act of 1952. Now, first we'll have a background about the EPFO, what exactly it is, because first understanding about applicability of its provisions over the proceedings under IBC, we first need to understand the intent behind establishment of an EPFO, why it was made, and why the dues, especially of provident funds of employees or their gratuity fund, pension, etc., they have certain priorities over other debts. So this was a statutory body. EPFO is a statutory body, creation of statute, incepted by Government of India. It was established in 1951 and it comes under the Ministry of Labor and Employment. Now, IBC, what it aims to protect is to protect all the stakeholders in the company. So not just employees, but even creditors, debtors, government dues, everything intended to be protected by the provisions of the code, and all stakeholders try to be taught in a balanced manner, keeping in view that the corporate also doesn't lose its own existence, and also maintains some other person who comes over and takes over as a resolution applicant. Also, he takes over the company as well as and doesn't pays certain dues of the creditors and takes over the business or assets to run another business, so that the companies are revived. They are not they don't go dead as in liquidation. It used to be done before the IBC was enacted. So it aims to protect relevant stakeholders, and now IBC is a consolidated code. We all know why it is called a code. So it has non-obstante clauses, which means its provisions will be overriding other provisions, other acts, in case there is a conflict. But when this IBC was enacted, perhaps when it came to Provident Fund dues of employees, so there was not much deliberation in the initial drafts. So how these Provident Fund dues will be treated under the CIRP was not really being talked about when the initial drafts of IBC were being framed, were being made. So later what happened, since no safeguard was provided to the Provident Fund and allied dues in the draft insolvency code, the EPFO's representatives, they briefed the Joint Parliamentary Committee, and they told them that the priority of payment of debts under the code should be changed. They also explained that there is a Schedule 11, which makes amendments to different provisions of different acts. So Schedule 11 of the code, it proposed Section 326 and 327 of the Companies Act should not be made applicable in the event of liquidation under the code. So there was an argument from EPFO's representatives that in case 326 and 327 of Companies Act is not held to be applicable to liquidation process, then Section 11 of the EPF Act, that will be rendered null and void. And EPF is also a special act where there is a preservation, there is a secured fund, EPF fund, which has priority over other debts in terms of Section 11 of the Act. So the committee recommended that all sums due to any workman employee from PF, pension fund, gratuity fund, it should not be included in the liquidation estate and estate of the bankrupt. And that's how we came to know, that's how 36(4)(a)(3), which we all know now, that how it came into existence. So it was not there in the initial draft, but these words, all sums due to any workmen or employees from the Provident Fund, pension fund, and gratuity fund, they were included. So this is in harmony with the Section 11 of the EPF Act, that IBC excludes gratuity fund, provident funds, pension funds. And this is the main intention behind this, is to provide social safety net for workers and employees, especially when we know that these workmen or employees may not be that much educated to preserve their own, to take care of their own interest, their own financial interest. And when a company is contributing to their funds, either from their own salary or from its own profits, then these statutory dues, which are for the welfare of these people, should be preserved. Now, the code has also deliberately and expressly kept the Provident Fund and Pension Fund arrears. We talk about arrears also, the arrears away from the clutches of the liquidation process. What does this mean? Like initially in the 53 waterfall, we see only 2 years workmen dues to be made, to be acceptable. But as far as these Provident Fund dues, gratuity dues are concerned, there is no limit. There is no time limit set, which means from inception, if these dues were there, then all of them have to be excluded from the liquidation estate. Now, the resolution profession can take control and custody of liquidation assets only after liquidating the entire dues payable by the corporate debtor. So these dues which are to be paid in priority, since they don't form part of the liquidation estate, so they should not be subject to the mercy of creditors or the priority ladder of the waterfall mechanism. Important section 11 of the EPF Act. We've already had some discussion, so I'll just quickly run through priority of payment of contributions over other debts. So in section 11 of the EPF Act specifically says, the marginal note says, there should be priority of payment of contributions over other debts, and where an employer is adjudicated insolvent or being a company. So this section 11 takes care of situations where the employer is already being adjudicated as insolvent. This act came in 1952. So at that time, IBC was not there. So the words used are adjudicated insolvent or being a company in order for winding up. So that was the only mode by which a company could become dead. So where a winding up order was passed, then the amount dues, as mentioned here, the EPF dues or the insurance fund, as they called in the act. So they were protected. They had to be paid in priority, paid in priority to all other debts in the distribution of the property of the insolvent or the assets of the company being wound up. So EPF dues always had priority over other debts even before the enactment of IBC. Subsection 2 of section 11 is important. Here it says that the amount due, which is the EPF dues, they shall be deemed to be the first charge on the assets of the establishment. What does this mean? That even if a mortgage, created by a corporate, that will also fail over the EPF dues. So this is relevant because it's a statutory commandment saying that the EPF dues will have the first charge over the assets of the establishment. And that is also containing a non-obstantive law that says that notwithstanding anything contained in any other law for the timing in force, be paid in priority to all other debts. The second important provision when we talk about interplay between IBC and EPFO is 36(4) of IBC, and it talks about the subsection 4 says that the following shall not be included in the liquidation estate assets and shall not be used for recovery in liquidation. And third point, which is relevant for us, is all sums due to any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund. So in a way, there is one concept known as legal fiction. We talk about legal fiction when we read the subject of interpretation of statutes. So when statutes are interpreted, these are concepts. So one concept is that fictions are created by law. Fictions are also given reality through the concept of legal fiction. So, for instance, there is one legal fiction that a company is a person. So, in effect, in reality, it is not. But that is how the law creates a legal fiction. Similarly, there is a legal fiction created in 36(4)(a), which expressly provides for exclusion of certain assets. So, assets which do belong to corporate debtor will not really belong to corporate debtor anymore because they are excluded by 36(4)(a). And that is how the legal fiction works. So corporate itself has no ownership rights on its properties to the extent of the dues it owed to the PF, pension fund, gratuity fund on the date of commencement of CIRP. Now this provision also is provided in explanation to section 18 of the Insolvency and Bankruptcy Code, which stipulates that the term assets shall not include the assets owned by a third party in possession of the corporate debtor held under trust. So they are the terms which are already being used, not just in 36, but also in section 18, that assets which are held under trust. And one of these EPF assets, EPF dues, which are there in the account, in the fund, they are actually the assets held by a company as a trust for the benefit of those beneficiary who are the employees. So In other words, an asset owned by a third party but in possession of CD shall not be included under section 18 also. Now, legal fiction regarding EPF dues, there are 4 facets to it. One is the purposive interpretation of section 36 of the code. Second is the first charge, which is created under section 11.2 of EPF. We had already briefly discussed this. Third is the usual observations that there is no conflict between the IBC and EPF Act. And fourth is the harmonious construction between section 36 of IBC and 18 of the code. Now, first facet, purpose of interpretation of section 36 of the code. So 36.4a3, we have already seen that it excludes all sums due to any workman or employee from the Provident Fund, pension fund, and gratuity fund from the liquidation estate of the corporate debtor, thereby excluding the same from the purview of the waterfall mechanism as enshrined under 53 of the code. So which means 36, since these Provident Fund, pension fund, and gratuity fund are excluded, so the liquidator is not supposed to treat them as part of section 53, since they don't form a part of the liquidation estate also. So they cannot be treated, they cannot be used for distribution under section 53. Then EPF claims raised against the assets of operator are often opposed by the liquidator or successful resolution are applicant by largely relying on term workmen's dues under 53B2, which does not cover EPF claims. So this, just to clarify that since they are not covered under 53, since they are not part of the liquidation estate in view of section 36.4a3. Now, we are continuing with this purposive interpretation of 36 of code. Supreme Court in this is one of the famous cases these days, Sunil Kumar Jain versus Sundaresh Bhatt. It has held that Provident Fund, so far as dues of Provident Fund, gratuity, and pension they are concerned, they shall be governed by 36.4.3, and they will move out of the ambit of liquidation estate assets. Therefore, the underlying part, section 53.1 IBC shall not be applicable to such dues, which are to be treated outside the liquidation process and liquidation estate assets under the IBC. It also further observes that the liquidator will have no claim over such dues. So this is an important judgment, clarificatory also, that the liquidator will have no claim over such dues, and these PF dues, gratuity, and pension, they will not form part of the liquidation estate. And there is one NCLAT judgment, State Bank of India versus Moser Wear Karmachari Union. Again, one important judgment. It also observes that there is a difference between distribution of assets and preference priority of workmen's. So they made a distinction that distribution of assets is one thing and preference priority of workmen's dues is another thing. So while applying section 53 of IBC, section 326 of Companies Act is relevant for limited purpose of understanding workmen's dues, which can be more than Provident Fund, pension fund, and gratuity fund kept aside and protected under 36.4.3. So in nutshell of this is that Provident Fund, pension fund, gratuity fund, they don't form part of the liquidation estate. Liquidator has no right to claim those assets since they always belong to the beneficiaries, who are the workmen and employees. Then recent judgment of jet aircraft. This is this has laid certain issues at rest. Jet aircraft maintenance engineers versus Ashish Chacharia. It talks about what it holds. This is the NCLAT judgment. It holds that we are satisfied that workmen are entitled for issuing appropriate direction to successful resolution applicant to make payment of workmen of Provident Fund and gratuity dues up to the date of insolvency commencement date, less the amount already received under the resolution plan towards Provident Fund and gratuity. So what we talked about till now was under liquidation. But how are these EPF dues treated under CIRP? And the answer has been given in jet aircraft judgment that a successful resolution applicant also should provide to pay in entirety the Provident Fund and gratuity dues and pension dues of the employees in line with 36.4. Though 36.4 is only applicable for liquidation proceedings, but this judgment specifically creates a liability against the resolution applicant, successful RA, that he should be paying this in full. So even if the resolution plan had provided, let us say, only 15% of these dues, this judgment will be applicable, and the remaining 85% will also have to be paid by the successful RA for the resolution plan also to be accepted. I hope so. This is one. I'll say this was not the initial intention, or let's say it is not written in the code that the resolution applicant has to provide the EPF dues in entirety. But this judgment has clarified this position, and in case the RA is not following this dictum, then the corporate debtor will go into liquidation. So the workmen and the employees are entitled to receive the amount of Provident Fund and gratuity in full. So that is clarified by ACLAT. This judgment was also challenged before the Supreme Court, and on 30th January 2023, in Jalan Fish Consortium versus Regional Provident Fund Commissioner, the ACLAT judgment has been upheld. So this is Section 326 of Companies Act, just for reference. So it specifies about overriding preferential payments and workmen dues, as you can see. Point A is one of the overriding preferential payment in the event of winding up of a company. Now, the second facet of our discussion is creation of first charge under Section 11, Clause 2 of the EPF Act. So Section 11, it gives statutory priority to the payment of EPF contributions over other debts. And subsection 1 relates to priority qua an employer who is adjudged insolvent. Subsection 2 and a company or a company being a company under order of winding up. So 11.1 is not only applicable to companies but also to an individual employer. So that is an important thing to know. Subsection 2, it talks about it is has a non-obstante clause, which means that this provision will have overriding effect over other provisions of other acts. And it lays down that if any amount is due from the employer, whether in respect of employee's contribution deducted from the wages of the employee or the employer's contribution, the same shall be deemed to be the first charge on the assets of the establishment, and shall, notwithstanding anything contained in any other law for the timing in force, be paid in priority to all other debts. To put it differently, subsection 2 of Section 11 does not only declares that the amount due from the employer towards contribution under the act shall be treated as first charge, but also lays down that they will also have priority over other debts. Now, priority, even before IBC, there was a Supreme Court judgment in 2009, Maharashtra State Cooperative Bank versus Assistant Provident Fund Commissioner. So that has already held that these dues, EPF dues and other dues under the EPF Act, they will be having priority. They will be superior to debts due to secured creditors. So the relevant part which has been highlighted, subsection 2 was designedly inserted in the Act. This is the observation of the Supreme Court, was designedly inserted in the Act for ensuring that the Provident Fund dues of the workers are not defeated by prior claims of secured or unsecured creditors. This is the reason why the legislature took care to declare that irrespective of time when a debt is created, in respect of the assets of the establishment, the dues payable under the Act would always remain first charge and shall be paid first out of the assets of the establishment, notwithstanding anything contained in any other law for the timing in force. So irrespective, the dues are also 20 years old, 40 years old, even then these dues have to be paid in priority in terms of section 11 clause 1 as well as clause 2. Now the third part of our discussion is that there is no conflict between the IBC and the EPF Act. So, so one of the major arguments which is usually put by the liquidator before courts or the successful RA is that for application of IBC vis-a-vis the provisions of EPF Act, IBC overrides EPF Act. However, the NCLAT in Tourism Finance Corporation versus Rainbow Papers has explicitly held that since no provisions of the code, IBC and EPF Act are in conflict, the application of 238 of the code does not arise. And why they say so? Because while dealing with the acceptance of resolution plan, those provisions do not talk anything about EPF dues. So that's why they've held that there is no conflict. So the Honorable Supreme Court concurred with the reasoning set out by NCLAT and in the Rainbow Papers case only, and refrained from interfering with the judgment, ultimately dismissing the appeal. So section 17B of the EPF Act also assumes relevance here, which creates an obligation on the transferee to pay the contribution. Transferee will be the establishment to pay the contribution and other sums due from the employer whenever an establishment is transferred. Therefore, by operation of 17B of EPF Act, the successful RA is made liable to pay the Provident Fund, which the corporate debtor owes to its employees. So now last part of our discussion on this is harmonious construction between section 36 and 18 of the code. The IBC is a single consolidated law which provides both options to the creditors, that is CIRP or liquidation, to successfully recover their dues from the CD. However, interestingly, 18F allows an IRP to take control and custody of the assets of the corporate debtor over which CD has ownership rights. However, explanation to section 18 of the code provides for some exceptions which do not fall under the scope of return assets of the CD. One of them being assets owned by third party, and EPF dues are nothing but the assets of employees lying in possession of the corporate debtor. So we've already discussed this, that assets of third party held by the corporate debtor in trust. So IRP will not be entitled to or even liable to take possession of those assets. So the courts have endorsed the view that EPF dues are assets of employees which are in possession of the corporate debtor, and therefore the same has been carved out of the liquidation estate under section 36 of the code during liquidation. Also, extending the same reasoning to section 18 of the code with respect to CRP, it can be rightly deduced that IRP cannot deal with EPF dues owed to the employees, even during the CRP. And this has also been clarified in Jet Aircraft judgment, which has already been discussed. So there, they have discussed, the NCLAT has also discussed the provision under section 18F, which talks about taking control and custody of assets of the CD, and as recorded in the balance sheet of the CD or with the IU or with the depository. And here, the explanation to section 18 specifically says that for the purpose of the section, assets shall not include. So there are three exceptions created. One is assets owned by a third party in possession of CD held under trust, assets of any Indian or foreign subsidiary, or other assets as may be notified. So subsection A, clause A of this explanation specifically excludes those assets which are being held under trust by the corporate debtor. And it was NCLAT has also observed that assets, PF, gratuity funds or pension funds, they are assets on which employees and workmen have right. Although assets are in possession and control of CD, the above mentioned assets are not to be taken control of by IRP. Also, these assets will also not be included in the IM, information memorandum. Now, there is another issue which sometimes arises, whether NCLAT, adjudicating authority, or the appellate authority, NCLAT, they can deal with EPF dues on merits. So section 60 clause 5, we all know about jurisdiction of NCLT over such matters where IBC are covered. So section 60 is talking about jurisdiction. 65, it states that notwithstanding anything to the contrary, the NCLT shall have jurisdiction to entertain and dispose of any application or proceeding by or against the corporate applicant or corporate person, or any claim made by or against the corporate applicant, or third, any question of proper priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings. So only the questions relating to insolvency resolution or liquidation proceedings are to be considered by the adjudicating authorities. In this Embassy Property Developments Limited, Supreme Court has held that NCLT and NCLAT do not have the jurisdiction to decide upon disputes under other enactments. There it was dealing with the enactment which is Mines and Minerals Development and Regulation Act, MMDR, where only the state government is having the statutory authority to that was the proper legal forum which was vested with the power of judicial review over administrative action. So in light of that judgment, also it can be said that NCLT and NCLATs have no jurisdiction to deal with the quantum of assessment made under the provisions of EPF Act. So whatever assessment EPFO does, it is the statutory remedy under the EPF Act which has to be taken recourse to, and not NCLT and NCLAT. So this is in short, we have discussed about EPFO. Any doubts or any clarity or anything, any participant wants to suggest anything, we can do that right now. Any doubts over the conflict, or here we won't say conflict, but any the interplay of IBC with EPF Act?
Sir, so is EPFO bound to file their claim during CIRP, or is this would rule even if they have not filed their claims?
See, actually, under the interpretation of these judgments, when you talk about claims, filing of claims, technically IRP is not even supposed to take control of these assets, EPF dues. But
Okay.
But having said that, EPF accounts cannot be operationalized without the consent of the corporate rector also. So EPF claims, in usual, we are inviting these claims.
Yeah, but just to say, if they have not filed, that does not dilute their position, or it is
Doesn't,
in
because
no way.
doesn't, because there are only two. See, we can only have two conclusions if they don't file claims. First, either in case there is a resolution, then jet aircraft judgment specifically says we have to pay 100% EPF dues, even if those claims are not filed. And second, in case it goes into liquidation, then automatically these EPF dues go out of the liquidation estate.
Only issue is because of the amount, because see the claim, see in books they may have whatever figure, like as you understand there are books not completed, or accounting is always an issue with these companies, and so according to me 100 rupees is as per books, and as per them it will be 125 rupees.
Right.
Now this you are not able to capture this information since they have not filed a claim in the IM. Now, as you said, if the RA has to pay the full amount, okay, he will say, chalo 100 rupiya bharna hai. He will mentally is clear, I have to pay 100 rupees. Now, then all of a sudden, if 125 comes, you understand, it affects the whole equation.
Yeah, so that's why. So usually as an IRP, you are an IP, sir, right?
Yeah.
Yeah. So as an IRP, it is our duty actually to even inform these EPFO, regional EPFO's offices about the commencement of insolvency, so that they can file their claim. So they can always provide you their assessment orders. And many a times assessments are not being done by EPFO before the commencement of CIRP. So in such cases, during the pendency of CIRP also, they will issue notices to you and they will make assessment before filing claim before you.
Fine. Thanks.
So so it is always better as an IRP to always indicate or always inform about the commencement of CIRP proceedings to the regional Provident Commissioner.
Sir, good afternoon, sir. Suppose the EPF authorities make a summary assessment and claim a random amount of some figures, X plus X into X amount they are asking, whereas the books of accounts shows a very little amount.
Right.
In that, the summary assessment also subsequent to the CARP period.
Yes.
Then how to go about that, sir, actually?
So just like how all companies do defend it, there is a provision of appeal, EPFO assessment. There is a provision under the EPF Act itself for making an appeal under before the appellate authority, and then later on even a writ petition is also filed against that further after. Even if you're not satisfied with the first appeal, then a writ is filed, but you can't go to NCLT because NCLT has no jurisdiction to decide upon on merits the quantum of EPF dues. So there is a statutory appeal where we can avail the remedy. We can defend the company also, just like a promoter. And I believe in case there is already an assessment prior to commencement of insolvency, then the promoters also must have already filed an appeal against that. In case the promoter has not, then we can presume those EPF dues have attained finality. Are you clear with me, or is there some?
No, sir. Actually, sir, I intimated to the EPF authority. They made a very nominal claim of, let's say, they made a claim form with a claim of only one employee's EPF. This one around a few thousand rupees. Later, as per the books of account, I said this is the amount which we have. We are taking it. That is a few lakhs it runs into. Immediately they started assessment, made an assessment, summary assessment, stating that the books of accounts were not available. So the last paid total EPF in the number of years, and this money is the total amount, like that, made a summary assessment and claimed X into X times of money. It's a very huge money they started asking. Now the assessment is subsequent to the CIRP claim, so we decided we rejected the claim actually because it was the assessment was made subsequent to the CIRP period. That was the stand taken, and we said there is the actual amount whatever payable to the employees 1-to-1 that is being calculated, and this is the amount. And we intimated to them. One of their officers said we will go to the court, and subsequently they are also hesitating to approach the court. Now, how to go about this, sir? It's under.
Sir, to be frank, legally, I mean, there is no bar to even income tax assessment or EPF assessment during CIRP. So, in case EPF assessment is being done after the commencement of CIRP, that is perfectly all right. I mean. I don't think so. We can reject a claim only because of the reason that after commencement of ERP, you initiated these proceedings, because moratorium is not applicable to internal proceedings by the department. Moratorium is only applicable if some claimant goes to a court of law and makes a claim. So moratorium is not applicable for internal assessment by these departments. So in such cases, I think you can because their assessment can only be challenged because they are a government authority under the act. So their assessment can only be challenged in appeal under that act. So as an IRP, I would not make myself. I mean, I would not take the responsibility of an EPF commissioner. So I will not say that your claim is denied and according to me, EPF dues are supposed to be only this much, because this is only supposed to be prerogative of the EPF commissioner, who will be making inspection through his own subordinate officers, and then inspection either of the premises or of the record, whatever it is, or whatever data is there. We all know that promoters don't help us in such situations. So whatever assessment they do, that can only be challenged in appeal. So that can be done.
Actually, that amount has to go to the individual employees. It is not that EPF authorities can enjoy the amount.
That is correct.
When I asked them the question, they said we will take it under a general fund. that is their that is their reply that the amount.
I know. Even I'm facing with this situation. So even like so what has happened usually many times when details of employees are available, then it is perfectly all right. Otherwise, what they do, they make an estimate out of the balance sheets. They make an estimate, okay, only maybe this many number of employees may be working, and so then we will cut EPF dues to that extent. I think perhaps you are talking about such a situation. Right?
No, it's here that in my case that employees list is available.
Okay. All right. But then they are calculating APF dues by taking more number of people as employees.
Yeah, because the companies during the last 3 years, the EPF was not remitted. And during the Corona period and subsequent period, the employees were left the company. The company is in a bad shape.
They have estimated more number of employees for the prior period for which even we don't have the list, right?
Yeah, that's right.
That's what you're saying. So yeah, so that's what I'm saying. So they always make an estimate on the basis of balance sheets. And since there were so many expenses by the corporate debtor, so many profits were earned, but there were so many expenses shown in the balance sheet on employees. So they make an estimate and do it. I know that they do. And perhaps even before the NCLAT, even I am also arguing a case for COC in which there is no list of beneficiaries available with EPFO, but then EPFO has claimed around 162 crores as EPFO dues. I mean, they've calculated, they've made claim of 42 crores plus calculated interest and something. So we are actually challenged that because in our case, resolution plan was not accepted because EPFO dues were not being paid by the RA. So we are, since because of jet aircraft judgment, we can't go on merit that these are not to be during CIRP, this EPFO dues won't have priority, but we have gone to the extent of challenging to the extent that saying that when beneficiaries details are not there even with EPFO, what will they do with this money? So, but that is subject matter which is right now under, it's a sub judice matter. So hopefully we can get some judgment in 4 or 5 months. But yes, you are right. Your point is well taken. In case they don't have list of beneficiaries, then they should not be charging, because we all know that then this government will go, EPFO will be only crediting this amount in their own general fund or whatever corpus they have, and this will not be utilized for the real beneficiaries. So the purpose of EPF Act was to give benefit to the real beneficiaries, but ultimately this fund only going in another account of the government. So that giving a chance of revival of a corporate debtor will this will certainly hit that. Absolutely, that is right. But having said that, I would say your initial observation that since they cannot make assessments during CIRP, that is perhaps not the correct legal position. They can make assessments. They can make assessments, and you can also challenge them in case you find it to be exorbitant, or you find them to be unreasonable. You can challenge them under the statutory remedy available under the EPF Act. Any other observations? Doubt? John sir, you were saying something? Yes, sir. John sir, you were saying something?
No, sir. Thank you for the reply.
All right. Any other feedback? Any other sharing of experience regarding EPF dues? This for the last 6 to 8 months, 1 year, this EPFO versus IBC has been a bone of contention before different courts. After Jet Airways judgment, the law has been settled that successful RA has to pay the entire 100% EPF dues. However, I'm saying even one of my matters as a lawyer, I'm representing COC in a matter that is under challenge. So where we are saying where the list is not available, the assessment is only on the basis of balance sheet. See, ultimately, my case is their liquidation value of the corporate debtor is around 45 crores. And the resolution applicant was paying around 50 crores. So EPFO dues, they come and say, our claim was of 40 crores plus interest, please give us 162 crores. Now, no RA will give 160 crores for a corporate debtor which has a liquidation value of 50 crores. So it's quite unreasonable also. And liquidation order was passed in our case by the NCLT following the Jet Airways judgment. But now we've challenged it, and NCLAT thankfully have issued a notice against them. They have also asked them to provide details of beneficiaries. So as far as this, this I would say this mischief, or I would say this this issue that give EPFO everything without inquiring whether they have the list of beneficiaries or not. I think perhaps we are going into that direction. Perhaps that EPFO should first provide details of all the beneficiaries to whom the amount will be credited to their account. In case beneficiaries are available, of course, then we should comply with that part because it's for their own welfare. But in case beneficiary list is not available, then I think giving chance to a corporate debtor for revival is more important than rather some fund lying in some bank account of the APF. Any other observations? Any other sharing of experience? I think nobody has dealt with EPFO. Okay, so we are done with the EPF part. I hope there are no doubts on this. Or see, one more thing I wanted to clarify. Even before IBC, when the Companies Act 1956 was there were judgments where judgments of the Supreme Court only, where it was it was actually held that in case of restructuring, or even where 391, 394 of Companies Act was applicable, where there was amalgamation or where there was scheme of arrangement, even in such cases, scheme of arrangement, even in such cases, 100% priority over debts was not the norm. It was only in liquidation, when the company is ordered to be wound up, that these assets will not form part of liquidation estate. That was the law. But after Jet Airways judgment, I would say resolution is akin to restructuring or scheme of restructuring that used to be there in Companies Act earlier. So in such cases, 100% EPF dues to be paid without even asking EPFO how you arrived at such finding, whether you have the details of beneficiaries with you. The interest being charged by you is actually 4 times the EPF dues you had calculated, which is also exorbitant. So these questions, perhaps we should be asking EPFO in fit cases where such issues arise. So we are through with this. We'll do Limitation Act now, and then we'll take a small break, and then we'll do ED. PMLA. Yeah, somebody was saying something? Yes, Murthy ji. I am unable to hear you, perhaps. Yeah, Murthy ji, I am unable to hear you. Can you please repeat what you said? Perhaps there is some connection issue.
Sir,
Am I audible? Am I audible to participants? Am I audible to the participants?
sir, am I audible now, sir? Murthy here once again.
Yes, yes, yes. Can you hear me?
Yeah, I am able to hear you, sir.
Yes,
Sorry.
yes.
Sir, actually, I am running one mandate for liquidation. So, usme actually this is case specific. See, there is no fund, either gratuity fund or PF fund.
Right.
Only 2 or 3 months of wages of March and April 2017 have been paid, and the corresponding PF amount has not been deposited.
No, but was EPF applicable in for such employees?
No, sir, it is not applicable. Actually, wages have not been paid, sir. If wages have not been paid, PF accrual doesn't happen, no, sir.
No, I don't know. See, EPF is applicable only in specific purpose. It is not applicable for all. For instance, let's say you hire one person in your office. You don't pay EPF dues, right? It's for establishments.
It's an establishment. It's a steel factory.
Establishments, and also for specific category of employees, right? For all employees who are covered under the act. I'm sorry.
Sir, it is an factory establishment, sir. So PF is applicable there.
Right. Now you are voluntary liquidation, no? You're saying.
No, it's not a voluntary liquidation, sir. It is a normal liquidation. CRP failed in liquidation process.
Okay, all right, sir. So then what is the issue then?
Sir, actually, the wages have been paid for 3 months where PF has not been deposited. It is much before 10 years before the stoppage of operations. 2013 March, April, wages were last paid.
There is a non-compliance.
So those 2 months ka PF is only in the outside estate. That's what I am actually of the view.
Yes.
Because baad mein salaries have not been paid, sir. If wages and salaries not paid, PF doesn't accrue, no, sir.
No, I would say I understand. No, wages were not paid, or wages were, those employees were working, but their wages were not paid, right?
Yes, sir. They were working because they were not terminated. Only by virtue of the order of liquidation, they got terminated. Otherwise, no terminations happened.
No, that's fine. What I'm trying to say is, let's say for 2-3 months, these employees worked, they got paid their wages, but EPF dues were not deposited, right?
Exactly.
Right? EPF contributions were not deposited.
Yes, sir. Exactly.
Right. But after those 2-3 months, were these employees working in the CD?
Sir, they were working. They are on rolls, sir, because the factory stopped.
I got it. They got terminated only upon liquidation. Legally, they got terminated. I got it. I'm saying whether otherwise they were working before commencement of CRP.
Yeah, they are on rolls, sir. They were on rolls before CARP.
But we have no evidence whether they were working or not.
No, they were coming to the factory, sitting for some time and going, sir. That's what has happened.
So, as an IR, were you the RP also in this case?
No, sir. No, I am also the liquidator, but took over recently from the earlier liquidator.
It's all right. Just okay. Did IRP accept the entire claims of employees till CRP, till commencement of CRP?
Sir, they have been accepted, sir.
Till commencement of CRP.
Yes, sir. Yes.
As a liquidator, also you have accepted the claims till the commencement of.
Sir, I was a liquidator who took over from the earlier liquidator recently,
Okay,
but the earlier liquidator accepted it. Yes.
Accepted till the liquidation commencement.
Yes.
Which means technically their claims were maintainable till they have worked till the liquidation.
Yes, sir. Yes.
Legally. Which means EPF contributions till that day had to be paid.
Sir, but EPF contributions have to be paid, but salaries have not been paid. EPF is accrued only when salaries are paid.
I got it, but subsequently, if salaries are paid,
No, salaries, sir, 24 months wages, only 10% will go to them, sir, as per the distribution mechanism.
No, that's why we've already read this. 53, that two years thing is applicable only for wages, not for EPF dues.
Sir, but wages, PF accrues only when wages are paid, sir. Otherwise, PF doesn't accrue, no, sir. See,
No,
standalone PF doesn't accrue when there is no fund.
No, that's correct. If there is no fund created, one is there was no need for creation of fund, it was not required to be paid. But if in case EPF fund was required to be made and the CD did not do it, the ex-promoters, they did not do it.
I have to just intervene, sir. See,
Right.
It was never a case of a fund. Always they were remitting with the help of a return to the EPFO.
Okay.
So there's no fund.
Okay. So I would say, as an RP, as an insolvency professional, or even as a liquidator, I would not want to go into that realm. I would want the authorities, EPFO, to decide what is their assessment.
Sir, they have given the claims that till today, till yesterday, till the start of CARP, even if the salaries are not paid, PF ka dues ka bana ke de diya.
That's what I'm saying. So, sir, under 53, you see 2 years salary or 2 years wages have to be considered. But in case 2 years is when it comes to priority, right? You must have accepted claims beyond 2 years, correct?
Yes.
You must have accepted claims beyond period. In case, I'm saying about hypothetical situation, in case all the waterfall is exhausted, then the remaining claims have to be paid.
Yes, sir. It has to be paid.
Correct.
Yes.
So it is not that under 53 you are paying only 2 years. That is only because it has a certain priority. those 2 years, those 2 years claim. But if it's a 10-year, let's say these wages are, let's say, hypothetically I'm saying, the wages for 5 years were due. Okay, 2 years are at a certain priority, remaining 3 years are at lower priority. Am I right? Am I right, sir?
True, sir.
Sir, 2 years at a particular priority, and then it is not as if after 2 years, I mean, they are not supposed to be paid at all. I am saying in case liquidation estate remains, has some balance left, then also the remaining claim has to be paid.
Yes, sir. It has to be paid.
Has to be paid.
Yes.
So then how can we bifurcate? Now EPF has further priority over all dues, even CRP costs,
Agreed.
right?
Sir, only EP, sir, these are all the cases where, see, during the stress period, the employer was collecting the PF, their share of PF, employee share of PF, and employer was contributing his share. He was not remitting to the PF department. That is what is estate, and that is having priority over 53. That amount is beyond 53.
Sir, that is why I'm saying, I think that is why as an IP, as an IRP or RP liquidator, whatever, I would not want to go into that realm. I would want EPFO to decide their assessment, make their assessment, and pay that amount, or keep that amount aside before counting in liquidation estate as a liquidator.
Okay, sir. Noted.
I mean, that is what is being held in these judgments. Instead, I know, I mean, we want to do justice to other claimants, but perhaps the law is this: EPF claims have to be given. They are not supposed to be part of liquidation estate. They have to be paid in full. 36(4)(a) is very clear. So
okay, sir.
that logic of 2 years will not come in for the purpose of payment of EPF dues. That will not come.
Okay, sir. Noted.
Right.
Thank you.
Any other doubt? Any other doubt, sir? EPFO. I think I was my presentation was clarifying to that extent that EPF dues stand. They are supposed to be treated aside from liquidation estate. They will not form part of the liquidation estate. Even the liquidator will have no claim over such EPF dues. Okay, there are judgments to that effect. I will be sharing these presentations later, so you can see. They will be helpful. Okay, now should we take a break or we start with Limitation Act?
Sir, one small query, one clarification.
Yes.
Am I audible, sir?
Yes, yes.
Sir, actually, we have to make the principal plus interest payment to the EPF. What about the damages, sir? Is it compulsory or optional? Only if you have funds, you can make payment. Otherwise, you need not.
No, there is no EPF dues when it comes to Provident Fund, because they are also even the damages. We are talking about compensation calculated under certain provisions of the EPF Act.
Pardon, sir?
EPF makes an assessment under different provisions of the EPF Act.
Okay.
So, are you talking about? Are you just asking in a?
No. In my liquidation assignment,
Right.
the EPF has raised the claim for till the date of liquidation.
Right.
But the workers were worked some 2 years prior to the commencement of liquidation. Thereafter, they never worked.
Right.
So, as per the waterfall mechanism, they are not entitled for the priority. 24 months, it's not coming. We are giving payment only for the period working during CIRP. Those employees or workers work during CIRP, for them we are paying as CIRP cost.
Right.
So for that period, I am ready to pay the damages also.
Right.
What about the period which is not covered? Subsequent to CIRP period?
I'm saying what I get from you is those employees who are not working during CIRP, right? For them, the subsequent payment should not be made. You're saying that, right?
The subsequent payments are not made. when we are not disbursing the salary itself, how the liability of PF will arise?
Correct. So you have also issued
And the company also doesn't function.
the
Company
CDR.
was shut.
You are also RP in that matter.
I am a liquidator in the matter.
Not
I'm
RP.
not. No, I'm not the RP.
Did the IRP or RP terminate the services?
When during IRP they were working, it was run as going on concern for quite some time. Thereafter, after COVID, it was shut.
So any termination letter was issued by the RP?
Termination only for selective employees, not for the workman.
Correct. So correct. So he had issued termination letter. So you are asking about only those terminated employees, EPF dues should not be paid for the remaining period, right?
No, I am asking up for everyone because everyone worked till COVID only. Thereafter, company was also not opened and they never worked at all. And
Okay.
for those periods, they have claimed, EPF has claimed principal, interest and damages. That we can reject.
No. You cannot reject. You have to tell the EPFO people. You have to that in the assessment, please make reassessment on the basis that so and so persons were not working during so and so period. We will revise the assessment and then that you can accept. Again, I'm saying as an RP, I will not touch upon their assessment.
Okay.
We can tell them please reassess because so and so employees, so many number of employees were not working so and so period. Maybe they will ask from you the letter of termination. You can say because it is under CRP, we were only having so many employees who are required to be working for the organization. You can say that. They should revise the assessment. In case they don't revise, then with the remedy is to file an appeal under the PF Act.
Remedy, we have to file an appeal in case if they are not revising.
Again, I'm trying. Again, I'm just
In my case,
yes.
I sent an email asking them to revise their claim and submit.
Right.
They said we are not inclined to revise the claim, but we are agreeing whatever amount you are paying. So that whatever amount admissible, whatever you are admitting, that is enough. You can make only that payment. We will accept.
So, which means a formal revised assessment order is not passed, but they're accepting your revision.
Yes. Oh, okay. I can revise and they are accepting.
So that's fine. If they
I need not go for appeal and all.
You can just keep that email in hand, email or whatever communication you had. That should be handy for you. That should be treated as a revised assessment only.
Okay, but they are very safe. They over phone only they informed. They have not replied my email.
Oh, no, you have to have something on record, please.
Okay, I will insist and give. Thank you, sir.
Any other doubts on EPFO? Okay, should we take a break or we start with Limitation Act? 1:30.
Yes, sir, we can take a break for 5.
We'll start at 3 o'clock.
Sure.
All right. Should we start with the session now?
Yes, sir, we can start with the session.
So now the second part of our session is on the relation or interplay of IBC with the Limitation Act. So I'll share the screen with you. All can see the screen. Yes. Can you see the screen, please?
Yes, yes, yes.
Okay, Limitation Act. So, right before beginning with the relation between or say interplay between IBC and Limitation Act, why was Limitation Act framed? Because most of us who are IPs, we all know, we've studied Limitation Act also, that Limitation Act is majorly to provide certainty over debts. Why Limitation Act was enacted? To provide certainty over debts. If a person, a creditor to whom debts are due or debts are owed, sorry, they are not taking steps to claim those amounts, either by approaching a court of law, then those debts, then it creates a right in favor of the debtor that he is absolved from making good those debts, paying those debts which are already time barred. So usually 3 years is the time period for money suits or recovery of money, and so that is why, as far as IBC is concerned, what we are concerned is only 3 years, because we are all dealing with recovery of money. So in case within 3 years creditor has not taken timely steps, then should that creditor be allowed to initiate insolvency proceedings against the corporate debtor or not? Or should such claims be allowed by IRP or not? These are main issues that we'll be dealing with. So we'll start with the history behind limitation and IBC, how they have worked. 238A, it now talks about section 238A. This is of the Insolvency and Bankruptcy Code. It talks about first, it was not there in 2016. 1st December 2016, when the code was made effective from. It came in June 2018. So it has some history, because initially NCLT had held that provisions of Limitation Act will not be applicable to IBC proceedings. So what it did, for instance, some IBC was enacted in 2016. Now, the debts of certain creditors, be it banks or even operational creditors, time-barred debts, which were due from, let's say, 2008, 2010, even those operational creditors or financial creditors were approaching NCLT, even when they had not filed any application before DRT, or even they had not filed any recovery suit before any court of law. They came in IBC and wanted to initiate insolvency proceedings in respect of those time-barred debts. Now, initially, NCLAT held that those applications will be maintainable, but then later Supreme Court held that no, NCLAT is wrong in holding that Limitation Act will not be applicable. Limitation Act will be applicable to IBC proceedings. Now, to give effect to that Supreme Court judgment, 238A was inserted by the Parliament. And this section provides for applicability of provisions of Limitation Act to proceedings or appeals before, please note this, to the proceedings or appeals before the adjudicating authorities, appellate authority, NCLAT, DRT, or DRAT. They were also the adjudicating authority in respect of individual insolvency cases. So this section only talks about section 7, 9, 10, or insolvency commencement proceedings. It is not talking about CIRP, claims, etc. Now, objectives of IBC in Babulal Gurjar versus Veer Gurjar, Supreme Court has held. First is to consolidate and amend all existing insolvency laws in India. Second is to simplify and expedite the IBC proceedings. To protect the interest of creditors. Fourth, to revive the company in a time-bound manner. And then to promote entrepreneurship. Now, to get the necessary relief to the creditors and consequently increase the credit supply in the economy, this is also one of the objectives. Then to work out a new and timely recovery procedure to be adopted by banks. Then IBBI has been set up. We all know this. So now the judgment of Supreme Court that I was talking about, that is BK Educational Services versus Parag Gupta. It held, so the issues that was there was whether the Limitation Act will be applicable to applications made under Section 7 or 9 of the code. And whether they should be commencing on from 1st December 2016 till 6 June 2018. So it was held that Limitation Act would apply to NCLT proceedings. As for 238A, the court said that it should be applied retrospectively. So 238A, which came in 2018, which was held, it was held to have applied retrospectively. That is from 1st December 2016 when the IBC came into force. So otherwise, applications seeking to resurrect time-barred claims would have to be allowed, not being covered by the law of limitation. So that will be a mischief in case that will also be an anomaly that time-barred debts before filed Section 7 or 9 filed for time-barred debts before which are filed before 6 June 2018, they were held to be if they are acceptable before and not after 6 June 2018, that will create an anomaly, also an uncertainty. And it is also not right because corporate debtor, a right has been created in favor of corporate debtor that or a company that time-barred claims cannot be enforced against that debtor. So, okay, and then the court further stated that the court cannot be triggered in the year 2017 for a debt which was time-barred, say in 1990, as that would lead to absurd and extreme consequences of the court being triggered by a stale or debt claim. So that is never the intention of IBC, that a money owed by a corporate some 15-20 years back or even before 3 years, that recourse having not been taken by the creditor earlier will be used. IBC will be used by such a creditor who has actually failed in enforcing his own claims on time. And then it was held that since the Limitation Act is applicable to applications filed under Section 7 and 9 from the inception of the code, Article 137 of the Limitation Act, which talks about 3 years as the time, gets attracted. Now, then there is an insolvency law committee which gave its report before the enactment of 238A in March 26, 2018. And Insolvency Law Committee, this was constituted by Ministry of Corporate Affairs to examine issues arising from the implementation of IBC. So it held that all decisions related to resolution or liquidation of insolvency firm are to be taken by COC. And then committee also gave its report. In its report stated that IBC is a complete code. In para 28, it said that the question of applicability of Limitation Act has been discussed in several judgments, such as it referred to a 56 Supreme Court judgment, stated that if a law is a complete code, then an express or necessary exclusion of Limitation Act should be respected. So then a 1992 Supreme Court judgment stated that the position on time-barred debts, stating that it is settled law that when a debt is barred by time, the right to remedy is time-barred. Debts in winding up proceedings cannot be time-barred as per a judgment of Delhi High Court. So now the analysis of the report was that non-application of the law of limitation, it reopens the right of financial and operational creditors holding time-barred debts under the Limitation Act. It reopens the right of claimants to file time-barred claims with the IRP-RP as a part of the resolution plan also. So then the intent of the court was not to present the code as a package for creditors and claimants to avail which did not exercise their remedy. So those who don't exercise their remedy on time, it is not a package for them to avail such remedies again. It is definitely not a relief package for such creditors. In Supreme Court, it was held that in 2015, before IBC, that limitation being procedural in nature would ordinarily be applied retrospectively. This was a reference to a new law of limitation providing for a longer period of limitation than that was provided earlier. So in the light of this judgment, the code came into force in 2016, but the So it cannot suddenly revive a debt which is no longer due as it is time bound. SBI as a Ramakrishnan, it's relating to guarantors. So here Insolvency Law Committee report was being referred also. It was held that the amendment made to section 14 of the code, which is moratorium, was held not to apply to guarantors, as this was held to be clarificatory and therefore retrospective in nature. The objective being an overbroad interpretation of section 14 ought to be set at rest by clarifying that this was never the intention of section 14 from very inception. Now, period of limitation in case of insolvency proceedings, this would start running from 1st December 2016 in case of earlier debts. So, NCLAT has held in Speculum Plus that the Limitation Act is not applicable for initiation of CIFE and must be determined with respect to Section 7 or Section 9 of the Limitation Act. If there is a delay of more than 3 years from the date of cause of action without any latches, the applicant can explain the delay. These decisions by the NCLAT allow creditors to initiate insolvency proceedings based on old debts, which could not be recovered due to expiry of limitation period. The expression debts then stands for debts that are due and payable and not time barred. Article 137 we've already discussed. Then it specifies the period of limitation in case of any other application for which no period of limitation is provided, and that is 3 years. So section 7, 9, 10 applications, they are covered under Article 137, and 3 years from the date of default will be applicable. Now, later judgments of Supreme Court 2021, Sheshnath Singh. So in this case, what happened? The financial creditor, which was a cooperative bank, it had initiated some SARFAESI proceedings against the corporate debtor. Now, the corporate debtor filed a writ petition in the High Court challenging the SARFAESI action. So the High Court was prima facie took a view that the FC could not invoke the provisions of SARFAESI Act. Now, during the pendency of SARFAESI proceedings, the financial creditor filed a Section 7 petition. It was held that the corporate debtor objected to the so the CD objected to the initiation of insolvency on grounds of application being time barred. Now, Supreme Court held that provisions of Section 14 of Limitation Act will be applicable in such case, and the benefit was given to the financial creditor. Now, what happens in those cases where the application is filed beyond 3 years from date of declaration of loan account as NPA? So, in Asset Reconstruction Company versus Tulip Star Hotels, Supreme Court has held that an application under Section 7 would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of NPA. If, however, only when there is an acknowledgement of debt by the corporate debtor before expiry of period of limitation, in which case the period of limitation would get extended by a further period of 3 years from the date of acknowledgement. Now, applicability of Section 14 of Limitation Act to proceedings under the code. So the Supreme Court held that, this is in Sheshnath Singh, the IBC does not exclude the application of Section 6 or 14 or 18 or any other provision of Limitation Act to the proceedings under the code. All the provisions of Limitation Act are applicable to proceedings in NCLT and CLAT to the extent feasible. And Section 14 also excludes the time spent in proceedings in a wrong forum. So in cases where in Sheshnath Singh, we've already read, SARFAESI action was already taken, which was set aside by Delhi High Court. So it was a wrong remedy taken by a cooperative bank, which was not entitled to initiate SARFAESI proceedings. But even then, Section 14 benefit was given to that cooperative bank by saying that if you had taken a wrong action before a wrong forum, that period can be excluded for counting those 3 years under which that Section 7 application can be filed. Lakshmi Bhat Surana, another important judgment of Supreme Court, which was given in 2021. So it discusses provisions of Section 18 of Limitation Act, which talks about acknowledgement. And it observes that before the expiration of prescribed period for a suit or application in respect of such property, an acknowledgement of liability in respect of property or right has been made in writing against, then in such cases, a fresh period of limitation will be computed from the time when the acknowledgement was signed. Supreme Court also noted that Section 18 gets attracted the moment acknowledgement in writing is signed by the party. In our case, it will be the CD, against whom such right to initiate resolution process under Section IBC endures. Section 18 would come into play every time the principal borrower or corporate guarantor acknowledges their liability to pay the debt. Further, the acknowledgement must be of a liability in respect of which the financial creditor can initiate action under Section IBC. So not just that there should be an acknowledgement, but also the acknowledgement should be of that liability only, that financial debt in respect of which that Section 7 IBC petition is to be filed. Then the applicability of the provisions of Section 18 of Limitation Act to proceedings under the code. The Supreme Court has held in SBI versus Krishi Dhan Seat that the provisions of Section 18 of Limitation Act are not alien to and are applicable to proceedings under the code, and an acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended, so long as the acknowledgement was within a period of 3 years. So an acknowledgement made even in the balance sheet has been found to be acceptable as an acknowledgement, which will create a fresh cause of fresh limitation of 3 years, period of limitation. Then asset reconstruction versus Bishal Jaiswal. So Bishal Jaiswal was, there is a background to this case also. The NCLAT had held by a 5-judge bench in a 4:1 ratio, 4 accepting and 1 dissent, stating that balance sheets, acknowledgement made in balance sheet will not be treated as acknowledgement for the purpose of Section 7 IBC proceedings. But then this decision was overruled by the Supreme Court in asset reconstruction versus Vishal Jaiswal. Here it was held that where the amount borrowed by a CD is reflected under its balance sheet, made or signed by a duly authorized agent of the company before the expiration of the prescribed period of limitation, this may amount to acknowledgement for the purpose of limitation. So the scope and ambit of Section 18 was discussed extensively in this judgment and how it is applicable to IBC. It also referred to 1962 Calcutta High Court judgment that there is a compulsion in law to prepare a balance sheet, but no compulsion to make any particular admission. So in case an admission is made in the balance sheet, then it amounts to an admission which will extend the period of limitation under Section 18 of the Limitation Act. Now, limitation for filing. When application is barred by limitation, Section 9. So wherein its application under Section 9, Section 9 is the OC's application. The applicant has mentioned 7th November 2013 as the date on which the debt becomes due. Then it cannot be argued that limitation commences from the said date. Therefore, application under Section 9 is not barred by limitation. So Limitation Act will be applicable to Section 9 also. And so it is not when the debt became due, but when the default occurs, when the limitation begins, period of limitation begins. Now, exclusion of time in proceedings, bona fide in court without jurisdiction. One we have already dealt in Sheshnath Singh, where surface action was done. Now, in this another judgment, the facts were that an application for initiation of CIRP may have been filed within 3 years from the date of enforcement. What is material is the date on which the right to sue accrues and whether the cause of action continues. The pendency of proceedings in a parallel forum invoked by the respondent is not sufficient cause for the delay in filing an application. So, in case some application was filed in a wrong forum, that benefit is available. But for instance, the financial creditor or even the operational creditor file a civil suit for recovery, then that benefit will not be given to them because they have pursued the correct remedy for a particular purpose, that is for recovery of that amount. But insolvency is meant for resolution of a corporate debtor. So the purpose is different. And in such cases, just because, let's say, an OA was filed, that does not mean that the 3 years time for initiating CIRP will be extended by filing of OA. And there is a recent pronouncement of Supreme Court where it has been held that proceedings in good faith in a forum which lacks jurisdiction or is unable to entertain for like nature may thus save limitation. Similarly, acknowledgement liability may have the effect of commencing a fresh period of limitation. That we've already discussed. And so limitation, applicability, exclusion of time of proceedings bona fide in court without jurisdiction, acknowledgement of present subsisting liability in respect of right claimed by opposite party. Does it have effect of commencing of a fresh period of limitation? Then yes was the answer given by the Supreme. Now, it was again observed that for the purpose of limitation, the relevant date is the date on which the right to sue accrues, which is the date when a default occurs. Now, another aspect of limitation is condonation of delay. So, for condonation of delay, NCLT and CLAT, they have the discretion to entertain an application appeal after the prescribed period of limitation. However, the condition precedent for exercise of such discretion is the existence of sufficient cause. So, Limitation Act also has a provision, Section 5, which says that it can condone the delay. The court can condone the delay in case it is found that there was sufficient cause for the applicant to not pursue its remedy within the prescribed period of limitation. However, that sufficient cause also has certain limitations. There are judgments. The law is quite liberal in that respect. Usually limitations, condonation is allowed in case there is no inordinate delay. And there is no, I mean, if it's a delay, a matter of some days, let's say 10 days, 12 days, 15 days, then it can be allowed. But if it's a matter of many years, then the courts strictly look into it. So this is all about limitation. It's just a revision. I think perhaps all of us are already aware about these judgments also. So all these judgments have indicated that Limitation Act will be applicable to IBC proceedings. Now, but there are certain questions also. I mean, there are some certain aspects on which the court is also silent. This also, I invite participants to have a discussion on this. For instance, a particular claim is time barred. Now, that claimant has not filed a Section 7 or Section 9 application, but as an operational creditor or even as a financial creditor, it files a claim before the IRP. Now, should the IRP accept such time barred claims or not? That is one issue that has not been answered properly in any case. Perhaps not, this issue is not being raised, or if this issue is being raised, then it has not been answered till date by any forum. So I would invite participants to have their view on this issue. Also, in case of any other issue, any other doubts relating to applicability of Limitation Act to IBC, you are free to ask those questions. Anyone who would want to begin with discussion on this? That whether should IRP be held to be, should IRP reject time barred claims or should allow? Considering that the applicant was not a Section 7 or Section 9 applicant, but he is just a claimant who filed a claim which are time barred.
Or sir, for this question, I'm getting different answer in different webinars.
Right. So
whether insolvency professional, IRP or RP or liquidator is entitled to admit the belated claim.
Right.
Few answers say yes, few say no. Liquidator has no adjudicating power, so liquidator cannot adjudicate upon the limitation aspect if it is received belatedly.
Liquidator has the adjudicatory power. IRP do not have adjudication power.
Right.
So is there any concrete provision what we have to follow?
So that is what I'm saying. IBC is silent. Regulation 13 is what is there. Regulation 13 of CIRP regulations. that talks about claims, collation of claims, verification of claims by the IRP. It doesn't talk about, well, it says that IRP will admit claims. So when it comes to admit claims, which means we have to verify claims. Verify claims, does it only amount to only verifying documentary evidence to show whether a claim existed? Is that where the inquiry ends? Or the IRP should also see that whether those claims are time barred or not.
So now one more question. In the Form A published by the IRP, there is a time cutoff time fixed. So last day to receive the claim is such and such a date. Then what is the point of fixing the date, last date?
We're talking about public announcement, right?
Yeah, I'm talking about public announcement.
Right.
The public announcement submitted by IRP in Form A or liquidator in Form B of liquidation regulation schedule. So we are fixing a date as a cutoff date to receive the claim. What is the purpose of that date? If we are receiving belatedly, how then why should we admit it?
So, see, as far as CRP is concerned, there are two purposes behind following a particular process, a particular time period. One is that the moment the insolvency CRP begins, the entire world should know that CRP has begun. So, public announcement is made, also telling the people in general through newspaper publications, etc., that CRP has begun, and you please file your claims before us within 14 days from the date of publication. Correct? Now, after that also IRP has to take some steps. Within 14 days, he receives the claims. Within 7 days, he has to verify all the claims and then form a committee of raters. Now, for the purpose of ascertaining the committee of raters, first you have to have those claims. So that is why a time-bound process that within 14 days we have to do it. I understand what you're trying to say is then what is the need for having a cutoff date if we have to accept the claims till 90 days, correct? But perhaps it is for the purpose of convenience of procedure that COC has to be formed at the earliest. Now, since COC should be formed by T plus 21, right? T plus 21, correct? So, no, T plus 21, yes. T plus 21 or T plus 23, something like that. So, in case COC is supposed to be formed within 21 days or 23 days, what is written in the act, in the code. So for that purpose, for that financial creditors, at least one should know who are they. And in case further claims are received, then at least IRP cannot be faulted upon for saying for not including that claimant as a COC member at the initial stage. Second is also for providing certainty to, because you also initially, now we have seen that IM should be published by has to be prepared by T plus 93 days, 95, T plus 95 something. Initially it was T plus 52 days. Now, for that time-bound process to culminate, we need to have certainty in a definite manner within time. So that is why these dates were given. I think your doubt was that why are then NCLT condoning delays? So that is the only power of NCLT. And practically also we see that not everybody is made aware. I'm talking about operational creditors as well as unorganized sector people. They are not usually made aware about the commencement of insolvency because we don't really need newspapers for looking at public announcements. So it is only through word of mouth when it spreads that one person knows that okay, an insolvency has begun in respect of a particular corporate debtor. In case I have certain claims, then I will only be, and then people take time to even understand how are we supposed to file claims. It is not easy for every, I mean, educated people can do it, but even they will find it hard to do it within 14 days. So that is why this extension till 90 days plus whatever continuation NCLT does.
So, matlab, finally, liability is there in balance sheet, say for 5 years. And I mean, see, sometimes it happens, as you understand in business, people just say, "Haan, paisa deta hu," and it is not necessary that every third year you are like on your shoe top of the shoe and that the creditor files a suit against you and do any. So it's sometimes mutual personal relations which extends the whole game. And then at the end of 5th year, if you feel nahi, ab mere ko, I want to now initiate IBC, this is going over my head. So will that balance sheet liability be okay? Because now that 3 years has left.
Correct. So balance sheet, the 3 years are gone. Balance sheet is filed every year. That period gets extended every year.
So, so the balance sheet date is considered. So if it is there in the balance sheet, so it's that from 31st March, say 23, we are talking. So 23rd March 23 say 3 saal. It's that way.
Correct. Provided
Even if the loan was say taken in 2010.
Yes. Provided two things we have to ensure. That let's say loan was taken in 2010 and let's say it became due in 2012. Okay, I'm just being hypothetical.
Yeah.
So which means default occurred on let's say 1st April 2012. Okay, default 31st March it was due, or 1st April it was due, 1st April 2012. Default occurred on 1st April 2012. Okay, now from 1st April 2012 to 1st April 2015, there should be an acknowledgement. So within 3 years, first there should be an extra acknowledgement. There should be something to extend. Let's say there is no acknowledgement from 2012 to 2019. Now we are in 2020. So 7 saal, because time barred, the debt becomes time barred in 3 years. 2015, the debt became time barred. Now in 2020, an acknowledgement cannot extend the period of limitation of a time barred debt. That extension can only be done of a subsisting debt, not a time barred. I hope I made.
No. So in that sense, again, so same question. If that there is no other confirmation, but it is standing in the balance sheet since 2012.
Yes, so every year, 2012 onwards, and every year that acknowledgement amounts to extending the prescribed period of limitation.
Okay, so you are saying that loan should not have been written back in the balance sheet in the period of 2012 to 15. And then if it is not done that, I mean, there is no right back. The company has not written back that loan, or it has not said that it is not payable karke. It continues to show in their liability. So it is fine. It is only if it is.
I'm not able to understand. Right back का क्या मतलब कहना चाह रहे हैं?
Company, see, I gave loan to company X.
Right.
X की balance sheet में liability में दिख रहा है, 10 में, 12 में भी दिख रहा है.
Correct.
15 में, चलो 14 में they have written back. मतलब they are saying now this liability is no more payable by them. Unilaterally they have passed one entry by which they have.
In the balance sheet they are saying there is no liability. Correct?
No liability. They are just pulling it off.
Okay.
I mean, it is unilateral. After all, they are making the balance sheet, so they can do that kind of entry.
See, acknowledgement कोई भी आएगी और unilaterally होगी, वो किसी एक आदमी की लिखी होगी. That is why it will be called an acknowledgement. Right.
So in 2014 उसने ये right back कर लिया, उसने liability से हटा दिया. So now then so you are saying since in after 14, say 3 years gets completed in 17. So in
not even 14 sir. 14 में तो आप कह रहे हो कि वो मान ही नहीं रहा.
हाँ 14 में वो मान नहीं रहा, मतलब 31 मार्च
13 में
राइट बैक कर लिया, तो
राइट बैक मतलब ठीक है, मतलब he is not accepting the liability.
हाँ he is not accepting the liability.
2013 में अगर उसने माना है बैलेंस शीट के अंदर क्लियर टर्म्स में, this amount has to be, it is one of the debts of the company. Then 2013 से आपके 3 साल शुरू हो जाएंगे. अगर 14 में वो नहीं उसे एक्सटेंड कर रहा तो 13 से 16 के बीच में फाइल करनी होगी.
Okay, understood.
We are being hypothetical. Section IBC came in 2016 only. But I think just to understand the concept.
Yeah, concept understanding. Thanks. Yeah.
Any other sharing of any experience related to Limitation Act? Anyone has? And I'm still not got my answers to IRP, whether he should reject time barred claims or not. One of our participants said there are many answers.
When he has no right to admit, he has no right to reject as well.
Correct. That's true. But then, which means, will you be admitting all claims irrespective whether documentary proof is there or not?
No, in support of their claim, they are submitting the documents. We will peruse the document, and if it is time barred, we can reject as mentioning it is time barred.
we can say not admitted, right?
Yes.
Not admitted. We won't use the word reject because there is a debate here whether liquidator is only the
Yes.
adjudicator.
Actually,
my
rejection of
opinion-
mere rejection of claim doesn't mean that it is adjudication. Even in my case, I rejected the claim, and then it was argued that the IRP has adjudicated. Then the NCLT very clearly stated mere rejection of claim doesn't mean that adjudication.
Correct. Absolutely.
So, in my opinion, I think until the resolution plan is not approved by the committee of creditors, the IRP should collate the claim.
No, actually 90 days is the time given in the regulations. So 14 days, but 90
I'm aware
days.
about 90 days time.
Yeah, after that, see, actually, it's, I won't say, I think you should leave it to, we should tell them to go to NCLT for seeking condonation. And once that is done, you can also give your no objection. before the
It can be placed before the committee of creditors also, because I've seen that NCLT in certain cases, they are asking whether the claim is placed before the committee of creditors or not, before not collating it or before giving the decision that no, I don't admit it. So, particularly NCLT Chandigarh, I have an opinion in NCLT Chandigarh. So, when there is a claim filed by somebody in NCLT that RP has rejected my claim, so NCLT is asking whether before rejecting, did you place the claim before COC? So, if you did not place the claim before COC, that means you have not rightly rejected it.
I don't think so. I think, no, placing them, they must have, perhaps they must be saying that whether you have provided the list of creditors to COC or not.
No, that is not it.
They are saying that whether you should, I don't know, COC has no right to perhaps go into adjudication into these issues. Perhaps,
Yes, sir.
in fact, because having adjudication over such claims might have some bearing on the voting share of the COC members also. So I don't think so. COC, it is neither the, it is the intention of the code to
Otherwise, after 90 days, any claimant that goes to NCLT invariably directing the RP to collate the claim.
correct.
So it's only increasing
It's a
the
formal,
complexity of litigation.
formal exercise, but I think
it's only a formal exercise.
it's a formal exercise because see there are limits to it. Let's say now this is something that you are saying that okay, practically or even if for all just purposes, we say that up till the resolution plan is received, we should keep accepting all claims. But where do we draw the line? That line has been drawn in the regulation. It's 90 days. Now, let's say you accept a claim which is 100 days after 100 days. You don't accept a claim after 140 days because the resolution plan is already received. Now that 140th per day rejected person can approach the NCLT and say, look, RP is acting discriminatingly, he's discriminating to the extent that even after 90 days, he's accepting some claims, he's not accepting some claims. So let's not get into that situation. Let's try to avoid and see why give any person a chance to say that you are not following regulations properly.
Absolutely. I think we have consensus on this. So that means after 90 days, RP should just
You should say approach the NCLT and informally, orally, you can say I will raise no objection. I will consider it, but once an order is passed by NCLT. It's all right.
So as far as this limitation is concerned, with respect to the guarantors, where the petition is to be filed under section 95. So what should be the criteria? Because promoters are generally asking the banks for OTAs for restructuring, etc. And as far as company is concerned, it is considered as acknowledgement of debt. And then, as you are just said, that balance sheet also it amounts to acknowledgement of debt.
You will also have BC letters, balance confirmation letters.
Now the bank initiates the SARFAESI proceedings. 13(2) is notices issued to the company as well as to the guarantors. No action is taken against the guarantors, but the company proceeds before DRT under surfacey against the company as well as the guarantors. Now, subsequently, the case comes to NCLT.
No,
Somebody
DRT, you're
files
saying
the
filing of an OA?
Subsequently, say bank only files NCLT petition, NCLT and CIRP is admitted.
Right.
And then now the bank wants to initiate proceedings against the personal guarantors also.
Personal guarantor, correct.
So now what is the aspect of limitation? Because the
Limitation.
acknowledgement of debt on behalf of the company, whether it would amount to acknowledgement of who are the personal guarantor also.
That's correct,
And
because
there may be 10
deed
personal guarantors. It's only one
of
person who has.
नहीं सर, गारंटी डीड के टर्म्स देखने होंगे. गारंटी डीड के टर्म्स में अगर आ जाता है कि प्रिंसिपल बोरर्स की एक्नॉलेजमेंट के साथ मेरी लायबिलिटी भी कोएक्सटेंसिवली आगे बढ़ती रहेगी.
आमतौर पे आज के बाद शायद ऐसी क्लॉज आ जाए, आमतौर पे पर्सनल गारंटीज में ऐसी
डीड ऑफ गारंटी, यूजुअली डीड ऑफ गारंटी में होती हैं क्लॉजेस. व्हाट आई हैव सीन माय ओन एक्सपीरियंस दैट डीड ऑफ गारंटी, बिकॉज़ बैंक्स के डॉक्यूमेंट्स इतने तो ऐसे होते हैं दैट दे इंश्योर दे विल टेक केयर ऑफ बैंक्स इंटरेस्ट्स. So am I able to hear? Are you able to hear me? I think मेरा नेट गया है या टुकराल जी का गया?
आपका नेट है सर. Your net is there.
Okay. So anyways, but he's not barred by limitation. Only internet is gone. So just to answer that, I think deed of guarantee के terms देख के we can ascertain if the deed of guarantee provides that my liability, of course, these liabilities are coextensive and they are coextensive, they go hand in hand. So in case there is an acknowledgement by the company, perhaps deed of guarantee के अंदर कोई ना कोई term मिल जाएगा जिसमें लिखा आता है कि हमारी debt भी साथ साथ extend होती रहेगी. That's why in cases of enhancement of credit facilities also, deed of guarantee subsequently दोबारा से execute नहीं की जाती, because वो automatically आगे extend हो जाती है. But so aspect of limitation, but we discussed about filing of claims actually. But what about adjudication? So we can, so I think we are right to that extent that IRP should not admit those claims which are time barred, because again, then that will amount to creation of unnecessary liability for a prospective RA. So why should we include time barred debts and random? That is also an issue.
Yeah, I'm sorry, I got disconnected.
Yes, but this is a clearer camera.
Yeah. So now I'm on the iPod actually. Earlier I was through the computer. So I was talking about the application of limitation with respect to the liability of the personal guarantor. So generally, guarantees that I have seen, generally they are not having the clause like the one you just mentioned, that the acknowledgement by the principal would also amount to acknowledgement by the guarantor. So generally what is happening, there may be more than one guarantors in a company. Generally there are 4 or 5 guarantors. So one or two, they may give a OTS proposal or maybe restructuring proposal to the bank. The others are not involved. So one is that if suppose I am a director of the company and I give acknowledgement on behalf of the company, whether that would be considered as an acknowledgement qua me in person also. That's one question. And second is, if I give an acknowledgement, whether that will be applicable to other guarantors also who are not there.
Right. So there are two things. I mean, actually, we are here about we are kind of getting into discussion about guarantors' liability. And again, I would only say I would not have a definite answer to this, but it will be depending on case-to-case basis.
No, I'm just restricting to the issue of limitation.
Yeah, so Limitation Act. See, again, actually, when you were disconnected, I was also saying this. Usually, जब enhancement of credit facilities भी होती है, जब enhancement of credit facilities भी होती हैं, तो तब भी deed of guarantee subsequently execute नहीं कराई जाती. Deed of guarantee के terms में आता है any enhancement or any other modification in the term in the loan that अगर वो principal borrower acknowledge करता है आगे, तो वो automatically guarantor की liability को होगी उसके साथ, क्योंकि कोएक्सटेंसिव होती है, तो उसके साथ चलती जाएगी. Now having this liability being coextensive, it happens. But in case deed of guarantee does not provide this term, then perhaps you have a case for guarantor. Then you have a case for guarantors. But wait, you are saying that you don't find such terms. In my experience, I find all these terms.
Okay, all right.
So that's why. So that's why I'm saying, depending on case to case basis, depending on the interpretation of the deed of guarantee. Otherwise, law of limitation वही रहेगा, वही section, सारे sections जो limitation act के हैं वो applicable होंगे. Acknowledgement के, part payment के, whatever, all those provisions will be there.
Right. Thank you very much.
Any other doubts? Any other?
Yeah, sir, I have one more question. Sir, this in a liquidation matter, the factory head, he's facing criminal proceeding. When the company was going concern, some accident happened. Based on the accident, the negligence part was, criminal case was filed against the factory head.
Right.
So now what happened thereafter, company went into CARP, and prior to that he resigned the job and he quit from the company. There is no connection at all whatsoever, but he is independently handling the criminal proceeding.
Right.
However, the victim's family was compensated by the corporate debtor.
Okay.
So victim has not approached the corporate debtor anymore. Only the person who is facing the criminal proceeding, he approached the liquidator asking for financial assistance. So I am facing the criminal proceeding.
Asking for financial assistance for?
Pardon, sir?
Financial assistance for what?
Because he is spending from his own pocket. He is paying advocate fees, the hearing charges, up and down court travel expenses, everything he is bearing. He is no longer connected with the corporate debtor also, but he is facing the criminal proceeding because it is filed in his personal name, personal capacity. So now, I being the liquidator, I informed him, you have not intimated about this to the IRP or RP or even to the liquidator within the claim period. Now you are approaching belatedly. I cannot entertain your claim. Kindly approach the NCLT. With the approval of NCLT, please submit your claim. I will entertain if there is such direction. Whether am I correct or anything else?
Else, till the time that you have not accepted his claim is fine. After that, I mean, you don't need to say it actually that you have to approach the NCLT. See, he is asking for something for a criminal let's say attending court matters, criminal court matters, where the company was also made a party, he was also made a party, right?
Yeah, yes, the
Yes.
previous occupier is also a party.
So he is not appearing for the company, but in his individual capacity, because he was
Yes.
made a co-accused.
Yes.
Now he
Yes.
was made a co-accused. Now, in the absence of any terms or any contract with the company, where the company says that company will be financially helping the Mr. X, whoever he is, for attending the court matters, there arises no contractual liability. Now he is just asking for on sympathetic grounds that perhaps, company was made a party and I was also appearing the matter because the accident happened in the company. Simple as that. But in law, because he was made a separate accused, he hired his own lawyer or whatever, he attended by himself, company should not be liable to pay that person unless there is an agreement with that company.
Okay.
Correct? I
Yes,
think
sir, yes.
able to
Yes,
clarify.
yes. Yes.
Very clear. There has to be some agreement between them. Otherwise, every other, for instance, I mean, it is his luck that he's been made an accused. Being being in a capacity as a manager of a company because he was having control over day-to-day activity of that particular area or department, whatever it is. So, but he was personally interested in that matter. So he cannot ask for any compensation or reimbursement or whatever from the company because there is no contract with the company.
Sir,
Okay.
invariably,
Thank you,
they may
sir.
not make the, sir, invariably they may not make the corporate debtor in the, as a party for the criminal activities. So the person who committed that activities only will be liable.
No, even the company must be made a party. I think we just need some clarification next meeting. I think company also must have been made a party.
Because one case, they haven't made the company as a party. Only the suspended director, he himself look into the matters actually.
No, but on paper, I think company also must have been made a party. Then under the concept of vicarious liability, the directors or the manager will come into the become co-accused persons under the concept of vicarious liability. But then in your case, Lakshmi,
It's the liability you are talking. It's a civil liability. When it comes to the criminal
I'm talking about
proceedings,
criminal also, sir. I'm talking about criminal also, criminal liability. Now, in cases of accidents and all, company is made a party, and the directors are also made a party. Of course, imprisonment cannot be made of a company. That is not a natural person. But there are cases where company might not be made an accused. But then without the company being made an accused, the other manager, director, etc., they cannot be made an accused.
actually for the criminal cases, the occupier, that whoever's names registered in the Factories Act or whatever, wherever it is, they take action against the occupier, not the debtor, corporate debtor.
Under the
Even for
factory
that
that the
case,
occupier must be the company only.
Sir, so many cases, only because of this one, the director appoints some extra people to take this responsibility. Even for so many other cases, other companies also, to escape from this liability, they appoint some people as a occupier, or they are in charge for for these type of activities. So that something happened, only that person will be answerable, not the directors.
Correct. There is, yeah. So what is your doubt? So what is your doubt then? Yes. Anything else? Or should we start with PMLA?
Sir, one final doubt with regard to limitation. It is not exactly for initiating the proceeding. There is one more doubt with regard to limitation only. See, stay has been granted by Supreme Court. So in the stay, it is clearly mentioned stay is for limited period.
You are talking about stay on what?
Stay of CARP.
Correct.
CARP proceeding has been stayed by Honorable Supreme Court for a
Right.
period of 8 weeks.
Okay.
8 weeks expired.
Right.
Stay is not extended.
Okay.
And it was not vacated as well.
No.
And there it was not vacated. It was neither extended nor vacated.
Okay.
Okay. And thereafter, some five or six times hearings happened.
All right.
As far as the extension of stay is concerned, the orders are silent.
Correct.
There is no discussion. Now, in the meantime, CARP period expired. Should we extend the CARP period? Should we file an application for extension or not?
No, first, by the look of it, I don't know, but whether what are the advocates who are appearing in Supreme Court saying on this?
I am not directly in touch with the advocates.
First, we have to see that whether the interim order, which was passed for 8 weeks,
Yes.
was it specifically saying that CIRP is stayed till next date of hearing, or was it saying it is only for 8 weeks?
It says that is very clear. The first time when the stay was granted, it was granted for 8 weeks and posted the matter. And thereafter hearings happened.
Just a second. The stay application was not disposed of, right?
Stay application, I think no.
Was not, because it was must have been the first date itself. After that, the hearings must have happened even on the stay application as well as on the main matter.
Yes.
That's why I'm saying on this clarity would be needed. I think perhaps whoever the IRP is, I think perhaps it is not your case. He should first seek clarification from his lawyer.
Okay.
What is actually happening? What are they presuming? Second, in case there is actually no clarification, one thing is that that particular RP must have been filing CRP7 form every month.
CRP7.
Right? CRP7 must have been filed. No?
What is that for? CRP7 is for?
CRP7 is for certain events. I mean, you can see it later on because we'll be running out of, we have to discuss one topic. But CRP7 is for, let's say, when the stay order is also passed. After that, there are certain steps which were to be taken, were not taken because of the stay order. So,
Okay,
of course, then 30 days must have elapsed, let's say, for the purpose of making of an IM, or for the purpose of RFRP document, which has to be submitted. Now, these are the steps. If they are not taken in time, then CRP7 has to be filed within 3 days from the due date of occurrence of that event. And it has to be filed every 30 days in case the times are not complied with.
Okay.
Right?
So this time extension, whether or not the time extension need to be filed or not, application for extension of time.
Yeah, so I would say first take clarification from lawyers in case they hold a view that stay is still going on. Then there is no need for seeking extension because CIRP proceedings were stayed from that day itself when the order was passed.
Okay.
On that day, you will not be counting it.
Okay. Fine, sir. Thank you.
But don't, please. But once you file the application at a later stage, after the stay is vacated, then you have to first mention it before the NCLT, maybe through
or exclusion.
Yeah, exclusion, or just while let's say how you have calculated those days. By excluding those days, they should be mentioned in your subsequent applications. Maybe when you are filing an application for after calculation, let's say 180 days also get over after excluding that stay period. Then also you have to file an application for extension of 90 days. So for that also you have to specify.
Okay.
You can also, but first hold a view whether stay is going on or not. If stay is not going on, then of course you have to take steps. You have to take extension, exclusion, whatever, all those things.
Okay, sir. Thank you.
Nishiji, you want to say?
Sir, my question is, like, CIRP 7 is also required for when the liquidation is filed with NCLT. Meanwhile, but the same has not come to board or something.
33.2 you are saying?
Yes, sir.
33.2. Yes, CRP 7 has to be filed if it is not disposed of in time. I am doing it in one matter for the last 7 months.
So if the dissolution order is passed, then CIRP 7 is not required, right?
Oh, of course, when CRP is culminated, then it's not required. Then you have to file then you have to file other disclosures because your RP period is now over. So you are demitting the office of RP. So then those forms will be filed.
So CIRP 7 is required when the application is pending with NCLT. We have to file every month.
See, it is not about. See, CRP 7 is not linked with NCLT. It is linked with a particular event. So if that event is not happening, then CRP 7 has to be filed from the due date of that event within 3 days. Correct? Are you worried about it? After that, if that event is not completed, then every month it has to be filed. So in our case, let's say proceedings have not 180 days have passed, right? 180 days must have passed in your case, 33-2.
Thank you, sir.
Okay. All right, so we'll start with the PMLA. We are only left with half an hour, so I'll just rush through. Yeah, you can see the slides. Are you able to see the screen? I've shared the screen.
Yes, sir.
Yes, we can.
Yes.
Okay, so now the last part of our session is about interplay of IBC with PMLA, Prevention of Money Laundering Act. So this is also one interesting issue, which is not yet properly settled to some extent. In some aspect it has been, on some aspect it has not been. Matters are pending before the Supreme Court also. So before beginning with understanding the complexity of the issues, what is PMLA? It is about enacting the fight against the criminal offense of legalizing the income profits from an illegal source. What does this mean? A person commits an offense, which is one of these offenses mentioned in the schedule of the PMLA, from Prevention of Money Laundering Act. In case whatever earnings he makes through such an offense, then the assets earned through such illegal earnings, they have to be confiscated. They are confiscated by the government. So primary objectives of PMLA are confiscating and seizing the proceeds of crime. That is the term they use, proceeds of crime, which are laundered, generated, or acquired through criminal activities. Then second is to establish a framework for prevention of money laundering and terrorist financing. Third is strengthening and improving the mechanism for investigation and prosecution of money laundering offenses. And the fourth is international cooperation in respect of these crimes. Then who is the authority which is responsible is the ED, which is the Enforcement Directorate, for enforcing the provisions of PMLA and investigating money laundering cases. Now, what does ED do? It investigates provisions, implements the provisions of FEMA and PMLA. It also has quasi-judicial powers to investigate and suspected contraventions of exchange control laws and regulations. Now, PMLA is a criminal law, wherein the officers concerned have the power to conduct inquiries, locate, provisionally attach, and then confiscate assets derived from the acts of scheduled offenses, besides arresting and prosecuting the money launderers. Now, in contrast, IBC is promulgated to reorganize insolvency resolution of corporate persons for maximization of value of assets. So the objects are quite different from each other. Now, important provisions. IBC has one provision known as Section 32A. And what does it do? 32A, it extinguishes the liability for prior offenses, liability of the corporate debtor. So where the change in management of control of corporate debtor is there, either pursuant to the acceptance of a resolution plan, then the promoter's management or control of corporate debtor, or with regard to the relevant investigating authority. So there is those liability for prior offenses will not be held by the new management. So the corporate debtor is exonerated. However, the existing prior management will be liable for these and will be liable to be prosecuted for these offenses. Then there is second provision which is important is Section 71 of PMLA. What it says, it has an overriding effect of other laws. Similar provision is there in 238 of the code, which has an override effect over other laws. So both provisions contain they are both special acts. Both say that they will be having overriding effect over the other laws where there is a conflict. Now, how are attachments made by the enforcement director and what are their effects? So the issue in this scenario is that while the PMLA provides for confiscation and attachment of property under Section 5, Section 32A of the code provides immunity to the corporate debtor for offense which is committed before the CIRP once it starts. Now, issue is also whether the powers of the ED under Section 5 of PMLA to attach assets of CD can be exercised once Section 32A of IBC has become applicable. So, Delhi High Court, Nitin Jain versus Enforcement Directorate, it had also considered an issue that whether the movable or immovable assets of the CD and the sale thereof during the liquidation process would be permitted under 32A of the IBC. So, here the issue was regarding sale of the corporate debtor which is under liquidation. So sale made during liquidation process. So whether it would be permitted under 32 of IBC where mobile assets of the corporate debtor were also attached by the ED. So High Court held that as soon as the liquidation process has been approved by the adjudicating authority, a statutory bar comes. And then the ED's power to attach assets under Section 5 of the PMLA would cease to exist automatically when the liquidation process order is given under IBC. And these are the observations of the High Court that the power to attach as conferred by Section 5 of PMLA would cease to be exercisable once any one of the measures specified in Regulation 32 of the liquidation process regulations comes to be adopted and approved by the adjudicating authority. Then the expression sale of liquidation assets must be construed accordingly. The power otherwise vested in the respondent under the PMLA to provisionally attach or move against the properties of the corporate debtor would stand foreclosed once the AA comes to approve the mode selected. So once the AA decides and approves a particular mode of sale which has been done by the liquidator, then to that extent, upon the adjudicating authority approving that particular measure, the PMLA must yield. So PMLA must yield means IBC has been given finality, overrides PMLA to that extent. Now, effects of attachment of property by ED, there are two facets to it. One is the effect of moratorium on attachment of property. Then second is Section 32A and its significance and how it is having effect. So first part is effect of moratorium on the attachment of property. So the NCLAT has held in Varsana Ispat Limited that I just read the highlighted part that the attachments made by the Deputy Director of Directorate of Enforcement much prior to initiation of CRP, the RP cannot derive any advantage out of Section 14. So what does this mean? Moratorium is not applicable to the attachment made by ED, and which also means that IRP cannot say that since that property now IBC proceedings have begun, CRP has been initiated, so I should take control of the assets which have been attached. Right. Then in the same line, another judgment, Kiran Shah versus ED, it says that mere running of the eye of the prevention of PMLA latently and patently indicates that it pertains to proceeds of crime and provides for penal action in respect of proceeds of crime. It is to be remembered that only when an endeavor is made to show the source of that money, it would amount to projecting the proceeds as untainted property. And one cannot brush aside the primordial fact that money laundering is an unlawful bustle through which the illegal, illegitimate proceeds take an outward appearance of legitimacy. In this connection, NCLAT recalls the decision of Supreme Court where it is observed that unearthing black money or checking money laundering is to be achieved to whatever extent possible. Although Section 14 deals with moratorium, this is important, it is not a hindrance for the authority and the officers under PMLA to deny a person of tainted proceeds of crime. Then in Delhi High Court in Rajiv Chakrabarti versus ED has held that through Section 32A, the legislature has authoritatively spoken of the terminal point whereafter the powers under PMLA would not be exercisable. And the non-obstante clause finding place in IBC can neither be interpreted nor countenanced to have an impact far greater than the that envisaged in 32A. So the consequences which have been mentioned in 32A, that are the only consequences which will be applicable and have effect on PMLA proceedings, nothing beyond that. These are definitions of proceeds of crime under PMLA, section 2IU, and then offense of money laundering has been defined in section 3, just for reference. So from the judgments which have been referred above, the moratorium under section 14 would not affect the attachment of tainted property of CD. So attachment will not be affected. However, moratorium would not affect attachment, notwithstanding the pendency of CIRP. Attachment under the PMLA is not an attachment for debt, but principally a measure to deprive an entity of property and assets which comprise proceeds of crime. So attachment is not taken as an attachment of a debt, but it is a measure, it is a preventive measure, so that a criminal cannot use the properties which has bought through certain proceeds of crime. The Delhi High Court in Nitin Jain versus ED has also answered the issue. This is relating to the second part, section 32A of the code and its significance. It has answered the issue related to whether the PMLA authorities would retain the jurisdiction authority to proceed against the properties of a CD once a liquidation measure has come to be approved. We've already discussed this. So the Delhi High Court has discussed a judgment of Supreme Court in Manish Kumar, and it has given its finding that PMLA has to yield to IBC and IBC will prevail over PMLA. So these are the observations. It's a part of the presentation. You can read this after. We'll be sharing this. And Supreme Court in Mahesh Kumar versus Union of India has also given a similar finding that provisions of IBC 32A will prevail over provisions of attachment of property under section 5 of PMLA. So relevant observation, corporate para 328, corporate debtor and its property in the context of scheme of the code constitute a distinct subject matter, such justifying the special treatment accorded to them. Creation of a criminal offense as also abolishing criminal liability must ordinarily be left to the judgment of legislature. Erecting a bar against action against the property of the CD, when viewed in the larger context of the objectives sought to be achieved, at the forefront of which is maximization of value of assets, which again is to be achieved at the earliest point of time, cannot become the subject of judicial veto on the ground of violation of Article 14. Now, and later, as to what priority must be accorded to which interest must remain a legislative value judgment. And if seemingly the legislature in its pursuit of greater good appears to jettison the interest of some, it cannot, unless it strikingly ill squares with some constitutional mandate, suffer invalidation. So which means 32A, courts have endorsed the consequences of section 32A, even in respect of cases where corporate debtor has been found to be held liable under PMLA. So the conclusion is that the legislature, by virtue of 32A, has chosen to step in and introduce a specific provision for cessation of liabilities and prosecution under the IBC. Neither the resolution nor the liquidation process set in motion ought to be hindered by any unforeseen or unexpected claims or events. Enforcement authorities such as ED will now have to limit its actions beyond the trigger event, pursuant to which the IBC shall protect the corporate debtor. While IBC may have imposed such a restriction, it cannot in any way be said to have curtailed the powers of ED to take action against the persons in charge of CD or involved in money laundering. So the liability of CD is extinguished, but as far as promoters or ex-management or other persons are concerned, directors, they will remain. So now both IBC and PMLA are special statutes. So who will have an overriding effect? So there has been a debate on this. So where two statutes contain a non-obstantive law, there is a conflict of provisions. The year in which the statutes which came to be enacted, that bears importance. The later one will prevail. That there are judgments on this aspect. So Calcutta High Court in Ram Sarup Industries has held that there is a presumption in favor of legislature being well aware and conscious of prevailing legislation at the time of enacting the statute. So when the IBC was enacted, PMLA also existed. And hence, vis-a-vis the PMLA, the IBC is a subsequent statute, and even at the first plus, the non-obstantive clauses and IBC ought to prevail over that of PMLA. Then in Rajiv Chakrabarti, Delhi High Court, it has been held that there can be no doubt that where two special statutes incorporate non-obstancy clause, it is the later enactment which would ordinarily or normally prevail. The same cannot possibly be recognized as constituting the solitary principle of interpretation which would apply. So first intention is always to create harmony between the two statutes, and only when there is conflict, then only it has to be seen which act will prevail. Right. So now conclusion. So what can be concluded is that section this would 32A would be the pivot by virtue of being the later act, and thus govern the extent to which the non-obstante clause would operate. And so when faced with the situation where both special legislations incorporate non-obstancy clause, it becomes duty of court to discern the true intent and scope of two legislations. Even though IBC and 238 thereof constitute later enactment, PMLA and PMA came in 2005, the court held that the extent to which the latter was intended to capitulate the IBC is an issue which must be answered on the basis of 32A. The introduction of provision in 2020 represents the last expression of intent of legislature, and thus the embodiment of the extent to which the provisions of PMLA are to give way to proceedings initiated under IBC. So PMLA has to give way to section 32A. That is the summary behind this. So this is the interplay of IBC and PMLA. So there are two things that we have learned from this. That one is applicability of 32A, how these provisions are made applicable to properties already attached by AD under PMLA. Second is that applicability of moratorium will not be there because properties attachment moratorium does not give relief to the IRP to the extent that properties which are already attached under PMLA, they are unattached only because of moratorium being applicable under CIRP. So I invite the participants to share their views on this topic. In case any experience, sharing any experience or any learning, or if there is any doubt on the issue, then I will be happy to help. Anyone who wants to say something regarding PMLA, IBC?
So may I ask one question? Am I audible?
Yes, yes.
Sir, how is the interplay between IBC 2016 and BUDS Act 2019?
And?
BUDS Act, Banning of Unregulated Deposits 2019 Act. Because last week I had a case wherein so many clients met me, and in fact, so much of money was collected by way of unregulated deposits. So in that case, if the total financial creditors, those people who have invested more than 1 crore, whether it will be going for IBC, that would be fine, or go for BUDS Act?
In case there are same remedies available, I mean, doctrine of election is what we call. So you can elect any of these two remedies.
But what if the BUDS Act, the competent authority, attaches the property? What has got that? How will they interpret with IBC?
No, just in case there is an attachment. So we have, I think this has not been made an issue anywhere. But in case there is an attachment, then perhaps similar consequences, because section 32A will still be there. Achha, but this is a 2019 Act.
Yeah.
So
the rules has also been notified. Last week I was with the
collector. Not really. I'm not aware about the provisions of this act. Actually, what is the name of the act?
Banning of Unregulated Deposits Act 2019. Banning of Unregulated Deposits Act. Yeah.
Banning of
Unregulated Deposits Act 2019. It was the notification. The state notification in Kerala has come in 2022.
Oh, these are okay.
This is a central act.
Banning of Unregulated Deposit Schemes Act.
Yeah.
Right. But is it related to?
So in one of our case, a liquidator has got a notice from the BUDS authority, the collector. So last week I had a similar case wherein so many 100 clients, they mostly will be coming under BUDS. So I've given a representation for butts, but there are other clients who have got more than 1 crore. So should I be going for the butts or should I be going for IBC?
It really depends what is the purpose you want to achieve. You really want to achieve for a resolution of the corporate debtor, then go for IBC.
No, but when there is a fraudulent activities happen, it won't go to IBC. No, but there should I be trusting more on butts?
Correct. That's true. If that is applicable, then.
So may I ask you a question?
Ji.
Suppose now the CIRP is commenced and completed, resolution plan is implemented.
Right.
Subsequently, it is discovered that the money invested by the resolution applicant is the crime money.
Is the proceeds of crime.
Crime proceeds of crime money, which is used for the CIRP process.
Okay.
And now the secured creditors are paid and all liabilities are discharged in accordance with the resolution plan.
Okay.
And now it comes forth that the resolution applicant has used the crime money. So
Right.
how that will be dealt?
So this is very interesting. So where the resolution applicant is the criminal. Right. Now, if the resolution plan has been approved by the adjudicating authority, I don't know whether if it is approved by the adjudicating authority.
Yeah, of course, it will be approved and implemented. Money
And
is paid.
if it is implemented to the extent that all the claims have been paid by the resolution applicant, then insofar as stakeholders and IBC are concerned, I don't think so anyone is going to be agreed. Who is going to be agreed is the person who must have paid to the resolution applicant, deposited money to the resolution applicant, who was cheated or who was otherwise the victim of these offences, one of those scheduled offences which are there under the PMLA. Now, looking from this perspective of the claimants or the stakeholders and IBC, I don't think so there will be any issue with regard to a person obtaining money from illegal sources and then and then resolving a corporate debtor. But from the perspective of later finding out that the resolution applicant is also a criminal to the extent that PMLA, he has first committed a scheduled offense and then with the wrongful gain it has earned, it has converted that money into corporate debtors assets. It has taken over those assets, to which has been approved by the NCLT also. Now, in such case, perhaps it is for the ED to approach the NCLT to seek confiscation of those properties, in case they are able to find a link that the criminal activity from which that offender must have, the RA must have earned the money that have gone into taking over the assets of the corporate debtor. But as far as stakeholders of IBC are concerned, I don't think so there will be any issue. They must have already.
Apparently, the assets are acquired maybe by using the crime money. So
Correct.
assets can be subject to attachment.
Yes, so that is for the ED to see. ED can.
Otherwise, as far as the NCLT is concerned, I don't think NCLT will have any power to.
Yes, correct. Because that corporate debtor's insolvency is over. So I don't think so. There is any issue in IBC. It was only in regard to ED.
It will be perfectly within the scope of PMLA itself.
Correct.
Right.
Any other queries?
So in short, if under a PMLA, if some asset is under the charge of ED or whatever, so then we should not disclose that in IM, or we should just make a disclosure that this asset will not come to you.
In case you are aware that these are attached assets, you have to disclose that in the
IM, but then these assets would not come to the RA. I mean, RA would not be able to take that asset.
No, 32A will be applicable. That is what, see, these are still, there are many cases going on. It is not a clear case, but Delhi High Court has held that 32A will be applicable, where liquidation proceedings where the mode of sale has been prescribed and that mode of sale has been approved by the NCLT, then in such cases, the attachment of confiscated assets will go and the IBC will prevail over PMLA. Now, insofar as CIRP is concerned, see, I
Yeah,
don't,
in CIRP.
I don't foresee many cases where you specify in the IM that these property are attached under ET, that any resolution applicant will actually come to take over the assets. But in case that happens, then also I think there are cases going on before NCLT and CLAT, before different different high courts also, where these questions are still sub judice. So there are judgments for and against both, for PMLA and against PMLA also. In this regard.
Okay.
But in the IM you should specify. Otherwise, tomorrow resolution applicant will say that IP did not specify this. So you should make a truthful disclosure.
Okay, thanks.
All right. Anything else? Any other queries regarding PMLA or even otherwise regarding limitation EPFO, regarding whatever we have covered in the last 3 hours? Okay, all right. I think thanks for enduring me for 3 hours. I think these were 3 heavy sessions. Limitation was still a bit simpler one, but EPFO and ED both are heavy topics actually, where matters are still sub judice, matters are still in issue. There are many issues which have been raised, not many issues being resolved. And I think we have also tried to highlight some issues in EPFO as well as in PMLA. So a good and very new different Tugralji had pointed out about where the resolution applicant itself becomes an offender, then what will happen? So something which could not be foreseen earlier, but a good learning experience for me in this session. At least everything is revised. So, is there any queries?
Thank you, Apoorv sir, for sparing your valuable time for the participants. Participants are free to ask any question if you have from the faculty.
So I have one more question, sir.
Right.
So suppose the corporate debtor's property is acquired by through proceeds of crime money. This is not known at this stage. Now the property is sold to a bona fide purchaser. Property is sold to a bona fide purchaser
By
liquidator.
okay.
And the bona fide purchaser has paid money to the liquidator. Now it comes to the notice of ED that this property was acquired through proceeds of crime money.
Right.
Now, whether he can ask the liquidator to hand over the money to the ED?
No, because again, that Delhi High Court judgment specifically says, even when they were aware that PMLA attachment proceedings were there, ED had attached the property. Even then, when the liquidation had sold the assets, and which was approved by NCLT, from that time itself, it triggered that PMLA has to yield to IBC. That is the expression they use. 32A will prevail, and so the attachment will be of no consequence thereafter.
Right. Thank you. Your session was very, very informative.
So, Apoorv sir, on behalf of ICSI IPA, I would like to extend formal vote of thanks to you for sparing your time for the participants and sharing this your knowledge on this particular topic, IBC and its interplay with various other laws. It was very interactive and very knowledgeable indeed for all of us. Thank you again for being with us for these 3 years. Thank you.
Thanks a lot. Thanks a lot. It was again
Thank
everything
you.
for me. Thanks a lot.
So I hope you'll be sharing the presentation.
Yes. I'll be sharing the PDF with
Thank you, sir.
Anjali, and I think perhaps they will be.
Thank
Thank
you,
you,
sir.
Mr. Apoorv.
Thank you. Thanks a lot.